SJC-10975, Commonwealth versus Wiggins et al.
Good morning, Mr. Black. Good morning, Your Honor. Give us 1 second while we get settled. Oh,
You want to move in?
we'll work it out. It's a problem when you go from 7 to 5 that we have
Okay.
we've not properly choreographed. But lest you be confused who people are.
Okay.
But you're still Mr. Black.
I'm still Mr. Black.
Good, good. Okay, you may proceed.
Thank you. If it may please the court, good morning, Your Honors, Mr. Chief Justice. My name is Attorney Black, as we just discussed, and I'm representing Mr. Wiggins in this matter. This case actually presents a fascinating and interesting factual development of the identification issue that this court has been addressing for the last several years. It's a case on first blush that looked like, okay, they knew these guys, so it's not an identification case, but clearly that wasn't the case, and the words that this court has used and the federal courts have used, slowly developed assurance, is clearly the operative phrase in this case. I mean, this was a case where there was an armed robbery and then a subsequent murder as the two perpetrators were fleeing the scene. And there were 4 people involved in the house at the time, 2 in one bedroom, 2 in the other bedroom. And various identifications occurred over the process of a day or two, and it ended up being, at trial, two people testified that they were very sure that these men were the men that committed the crime.
So it's a little unusual here because the men are masked.
Yes.
So you're not saying that if people know each other and there's, out of precaution, an out-of-court identification procedure utilized, that people who have known each other can't say, "Yeah, that's him, that's the person who came into my house," are you? Is it the uniqueness of them being masked?
Well, and usually if they know them and they're not masked, it's not an identification case. I mean,
So is that the uniqueness here?
But the uniqueness is they're masked, and they none of the 4 initially said it was the defendant or the co-defendant. None of the 4.
Excuse me 1 second.
Okay. So that means I haven't started yet? I have.
But your time has
I
not
see your
started.
time.
That's all right.
The unusual part of this case is, yes, they knew each other, but yes, they were masked, and after the fact, 4 of them didn't pick out the defendants. 4 of them didn't say who they were. None of them did at the time.
I'm sorry, you said that, but I'm sorry.
Yeah, no.
What about Cologne?
Yeah.
I mean, Cologne, I thought.
So Cologne made a
said he
911 call.
recognized Mr. Laporte, and then I get.
Made the 911 call. So Cologne is the one that is very different than Bennett. I think Bennett is the most serious issue here for us. But Cologne makes a 911 call and says the following. Says 2 people, gives a description. The description's a little bit different than some of the other descriptions, and does not name the defendants.
So that's not the same as not making an identification.
I mean, it doesn't say who they are, and he knows them for years.
Doesn't he, I thought he did identify
Not on the 911 call.
and how about Sergeant Duda?
And as a matter of fact, what he says is, in the 911 call, which is contemporaneous with the incident, he says, "I know nothing, I don't know anything about what happened." His words, at the time, okay? Yes, he is the fastest to say, "I told Duda that I think it's Wiggins, I think it's Laporte." But that's still not contemporaneous to what happened. Bennett, on the other hand, goes to the suggestive ID, which was ruled suggestive by the trial court, and says, "I don't think it's them." In the identification, the one that is suggestive still doesn't pick them out. Neither does Susan Bennett. Now, at trial, Daniel Bennett says, "Yeah, for sure. I am sure now. But the developed assuredness occurred after that 3-hour interview with Kervick, Detective Kervick, where one, he told him, by the way, your mom died, and two, showed him some of the items seized from Mr. Laporte's house.
Did he,
Now he's sure.
did he tell Daniel, because I think we have two Bennetts, we got Susan.
Susan and
we got
Daniel,
Susan,
correct.
So let's use first names for the Bennetts at least. Did he tell Daniel that we found these at Laporte's home, or did he just show them that we have them?
I believe he told him where he found them and said, this is all the stuff that we discovered. Correct.
Discovered
Laporte's house, in
Laporte's
Laporte's
house?
closet?
I'm sorry?
In Laporte's house or closet?
In the closet in Laporte's house. Yes, correct. After a 3-hour interview, and my understanding at the trial was 2 hours, he never said anything, and the last hour after he found out that his mom died, now I'm sure.
And what I could not get a sense of from the briefs, and I, of course, have not read the transcript, is whether or not there was the view that Daniel actually knew, but but I didn't get the sense. I mean, we have those cases. I couldn't tell whether this was, that was the view of the trial judge or whatever, that, yeah, he knew from the beginning, but he wasn't going to give up his good friend until he learned that his mom had died.
Because hadn't he identified, I think it's Laporte who said who was his best friend, is that right?
My client, Mr. Wiggins, was Daniel's best friend. Angel testified that he knew him since middle school. They were at the house 2 hours prior to the incident. The testimony was that they were at the house 4 to 5 times a week. Remember, the question that was first asked was, do you have any African-American friends that are drug users? I mean, there's some indication that Daniel Bennett was selling drugs in the house, and they asked, do you have any customers? Yeah. And he said, no, but I have 2 African-American friends, and that's what led the police over to the Laporte house.
But before we got there, I thought that Daniel, I think it was Daniel, said to somebody, and made a call. I hope it is not.
Yes.
Right?
You are absolutely right. He made a call to a girlfriend.
His sister or girlfriend?
His girlfriend, and said, I hope it's not him. And then when they had the suggestive ID procedure, said it's not him, and didn't pick him out while he's standing handcuffed in front of a car alone.
Let me ask you this. Put aside common law availability of finding an out-of-court ID is unnecessarily suggestive. Just put aside that. I'm just trying to get at what you're ultimately looking for in the real world. So the motion judge finds that by clear and convincing evidence that there's an independent source of the ID. And in fact, there's overwhelming evidence in the case that the alleged victims knew the perpetrators and that Daniel was friends with them.
Correct.
So if there is an equivocal out-of-court identification or an out-of-court identification is unnecessarily suggestive, and the alleged victim or a witness knows the people,
Yes.
what should happen?
Well, I'm asking, I know this court ruled in the recent Johnson case about the independent source rule. I'm asking that the independent source rule be done away with.
So what would happen? You know, the alleged victims' witnesses know the perpetrators. There's an equivocal out-of-court ID for a multiplicity of reasons, including it could be fear, it could be friendship, whatever it might be.
Can't make an in-court ID.
So the person who knows the perpetrators can't say who did it.
Can't say that those people were the ones in their house because they weren't able to. They weren't able to then, contemporaneously.
Well, that's a good weight issue. I just want to make sure I know where you're going.
That's where I'm going.
Where you're going is that people who know each other cannot say who did it.
Respectfully, you're making a generalization where I'm not doing that. I think this set of facts is fascinating to me because it adds all that together. You have people who know each other, but they were masked. You have people who could not pick them out immediately.
Could not or would not?
Well,
Because I mean, I, just going back to the chief's question, wasn't there some suggestion that they didn't speak up because they were friends? And
well, that's a fascinating, that is a fascinating comment, although I read the transcripts over and over again. I never got the sense that that's what was happening here. First of all, Angel Cologne clearly hated them and wanted to go forward with what he wanted to do. Susan Bennett couldn't identify them. The other woman in the other room couldn't either. So what you got is Daniel Bennett. And Daniel Bennett said specifically, it is not them at the suggestive ID. Now, if you're suggesting that he said that because he was his buddy, his testimony was, I want to make sure it's not him. And matter of fact, he was about to get into a car and follow them because he really wanted to exclude them, but he wanted to make sure. And then he said, no, it's not him. But then, of course, Detective Kervik showed him the stuff. And then he said, yeah, it's him. But isn't that exactly what we're talking about the slowly developed assurance? They
Let me
weren't
ask
sure
you
at the
about
beginning.
the Johnson question. You say in your reply brief, I think it is,
Yes.
that you think that this is the case. Why do you say that?
Because of and I think it's just as Loie is saying, because of the interesting fact pattern that you have here. You have a case where the judge said clearly, the motion judge said clearly, this is a suggestive ID. He made a ruling about Daniel Bennett and said Daniel Bennett had his ruling about Daniel Bennett, and I'm paraphrasing, the judge's ruling was that Daniel Bennett was very unsure about everything. He was unsure about all of it. It's not him. I don't know that it's him. I have to call somebody. Maybe I'll follow him to the house. And then the next day, he gets involved in a 3-hour interview where supposedly the first 2 hours, he didn't say anything. And by the way, this is the stuff we found. By the way, your mom died. Okay, it's him. Now, to me, the reason why I'm saying that this is a case to do away with the independent source rule, isn't this a case where the independent source rule actually led to an in-court identification where nobody could identify him initially at the very beginning of the case?
I was thinking that I think the court might have meant, I don't know what was meant, but the question that was left open in the Johnson case wouldn't apply to this kind of situation where the victim and, well, not the victim in this case, but the persons who are making the ID have a prior relationship. I mean, it's not like somebody saw them for 5 minutes on a street corner somewhere. I just don't see a reason why this would be the case to say that we're no longer going to follow the independent source rule, because this case does not raise a question about the vitality of that rule.
Well, to me it does. To me, it is the allowance of them to make an in-court ID when 4 out of the 4 witnesses were not able to identify them previously, and you could almost see the developed assuredness just rise as this whole proceeding progressed. And if it wasn't for the independent source rule, there wouldn't be an in-court identification, because our argument is that the in-court identification is solely based on all this stuff that occurred before the showing of the items, the suggestive identification
But you
procedure.
can't say that if they knew each other.
But they were masked.
Well, they recognized the voices,
Well, did they? I mean,
what they said.
okay, one of them said they recognized the voices, but the court, of course, ruled that that was suggestive. I'm talking about the procedure. The other one also said it was suggestive, but Daniel Bennett, don't forget, Daniel Bennett didn't recognize him even with the voice. They did do a voice for Daniel as well as Susan. Susan says, I don't think it's them. And the fourth person said, I don't think it's them at all. But you do have a couple of very sure in-court identifications But isn't that because of all the suggestibility that we're talking about? I mean, it's a case that is really full of stuff. Because you've got the mask, yes, they recognized him. But they didn't know who they were because of the mask. And then, these were my buddies. They were just here 2 hours before. And then all of a sudden, I don't know who they are. I don't know who they are. And now all of a sudden at the very end, yes, that's for sure them. I mean, isn't that what the doing away the independent source rule would protect that from that happening in a case like this? And I really recognize this case as a very interesting set of facts.
So are you saying that we should do away with the independent source rule when somebody's masked, or that if there's an out-of-court ID that's unnecessarily suggestive, but the person who's making the ID has been neighbors with the alleged perpetrator for 3, 4, 5, 6 decades, they can't say who it is?
I think this court was talking in Johnson, if I'm getting it right, I hope I am, that doing away with the independent source rule completely. Not just for any specific fact pattern, but completely, because it is a trap for the unwary, and a trap for somebody to be convicted in a situation like this, where, I mean, you could almost see chronologically how this suggestibility developed.
So there's all sorts of cases that are not ID cases. They're not ID cases, they're not ID defenses, and there was an out-of-court identification procedure that was utilized for all sorts of reasons. So the out-of-court ID procedure is a show-up when it shouldn't have been a show-up. The defense in the case might be lack of criminal responsibility. The witness on the witness stand, who is the alleged victim, let's say, of a B&E, can't say, because of that out-of-court ID, that it was my neighbor who I've known for 50 years.
Wouldn't be able to say that if the independent source rule was not in existence. But would be able to say it if it was. And then, of course, you have the traditional independent source rule analysis, which the judge did, although I did point out in the brief that I think the judge made some errors in terms of his facts. He said that both Susan and Angel had a very good opportunity to observe my client going down the hallway, and Susan specifically said she saw him for 2 seconds. So I think it was wrong. So I think it's actually incorrectly applied as well. But I know this court. I've been reading the Collins and Creighton and Johnson decisions for the last year with much interest, and to me, it appears that this is the case to reach that issue.
Is it your view that the independent source rule, that the problem with it is that if you have a suggestive ID before, that it's as a practical matter impossible to be independent? That there's nothing that would make it independent?
And that's why this case is different than Johnson, is because you do have a procedure that has been, and is, I would say, deemed to be suggested. I mean, the one person in front of the car, handcuffed. Yes, I would say that to answer your question, I'd say yes, and I think that's what I'm arguing.
But there are two issues. Even if we have an independent source doctrine, I assume you're saying that the judge was clearly erroneous in finding that there was clear and convincing evidence, at least as to Daniel. Well, Susan doesn't matter because Susan didn't identify your client at trial.
Or at the procedure, correct.
Right. So it's really Daniel. I guess you argue Susan because you say if the judge said that there was independent source for Susan's identification of your client, then that indicates just how wrong he was, I assume, correct?
Correct.
But let's imagine that you are right. Which happens sometimes. Let's imagine that the judge did err in finding, at least with regard to Daniel, that there was independent source. We can differ about Cologne, but Cologne did appear to at least tell people at the scene that he identified both Wiggins and Laporte.
After the 911 call, correct.
911 call, not during that call.
Yes.
Daniel, I take all your points, but Daniel, I assume that it would come into evidence that Daniel called Wiggins' sister after the event and said, I sure hope it wasn't him.
Correct.
Which at least indicated that he suspected that it might be. That would come into evidence.
Either that he suspected or that he was hearing things at the scene from Angel or the officers, and that's not clear from the record.
But the fact, but even if it would be, even if the ID would be suppressed at trial, the fact that he made that phone call would come in, I would think.
I understand your point.
And then you have the fact that the stuff was found in Laporte's closet. Would it be, would any error be harmless if all that other stuff would come in?
I anticipated that question. The argument, I think, that was made loosely at trial was that there were other people that lived at that house, Laporte's siblings, as a matter of fact. It was certainly a possibility that I think that was sort of an argument that other people were involved, not these two. The issue about, and then I think this dovetails as to the issue number 3, which I would like to actually mention. I only have 141 left, but that's the waiver of the where co-counsel got into an identification that was already suppressed and was able to elicit another identification from Daniel Bennett at the police station, and that said, yes, it was Mr. Wiggins. That was suppressed. And so now the prejudice comes in where you've got all these identifications, and now you have a suppressed statement, which came in to Detective Kervick from, and our argument was that I don't think the co-defendant can waive the defendant's constitutional rights, and I don't think so. But that's where the prejudice comes in, because you have that as well.
Didn't the trial counsel for your client say at the time, I didn't object because, I mean, it was sort of, the inference to be drawn was that he intentionally did not object because he thought it was going to be helpful or something.
No, not because it was helpful. He thought it came in, quote, quietly. So, as a trial lawyer also, you don't want to jump up and down on something that it came in already.
Yeah.
And furthermore, he was objecting to Ms. Brandt's, the ADA, trying to lead another witness, an officer witness, into coming out with stuff about the suppressed identification. And I am out of time. So thank you very much, and I'll just rest on the rest of the brief. Thank you. Thank you, Your Honors.
Mr. Baylor, good morning.
Good morning. May it please the court. Jeffrey Baylor for Swinkle's Laporte. I'd like to begin by addressing Mr. Laporte's sentencing issue, unless the court would like to hear otherwise. Mr. Laporte, who was a juvenile at the time of the offense, was convicted of first-degree murder, felony murder, and received a life sentence. After this case, the court's case in Dychenko, his parole eligibility was reduced to 15 years. Along with the murder conviction, he was also convicted of home invasion and received a 30 to 35-year sentence, and armed robbery, where he received a 20 to 30-year sentence, which would give him parole eligibility on the home invasion of 30 years, double the murder, and on the armed robbery, 20 years.
They were served, to be served concurrently, correct?
Concurrently. He received the consecutive sentences that were changed to concurrent by the appellate division.
What, under the legislation that passed in, I think, 2014, I appreciate it doesn't apply here, but can you just remind me what the new, for first-degree murder, if you're a juvenile, what the new time period is?
Yes, that's 27924. I even brought it with me. It's for felony murder, it would be 20 years.
Okay.
For premeditation, it's 25, and for extreme atrocity, it's 30. So in a case like this, it would be 20 years.
Because they were only convicted of felony murder?
They were only convicted of felony murder, yes. They also received instructions on premeditation, but they only came back with felony murder. We contend that these 30 and 20-year parole eligibilities are cruel and unusual, or cruel or unusual under the state statute, because they were not proportionate to Mr. Laporte as a juvenile or to the offense when compared with murder.
In this case or in general?
Well, in this case, based on his characteristics as a juvenile, but in general, it should be applied to, would be applied to all juveniles.
So there couldn't be a crime where the judge could think that the egregiousness of the conduct warranted a sentence of more than, say, 21 years if it's a...
Well, it's not a question of the upper limit of the sentence. It's a question of the lower limit. So he was, for example, he received 30 to 35 years for home invasion. So that only allows him parole eligibility after 30 years. So we're not saying that...
30 years minus earned good time.
Right, which, as I understand, would not likely be much, if anything.
Why?
Why?
Because it wouldn't start until 20 years, after 20 years?
You know, I can't say that I...
That's on day one.
I don't think you get good time during a mandatory. So he would, the good time, I think, would kick in after the 20 years had been served.
Okay, yeah, I mean, that isn't something that I reviewed, but yeah, it was my understanding that it would not amount to much.
Can you help me with regard to the felony? What was the underlying felony?
Well, it was both home invasion and armed robbery.
Okay, but usually that's a lesser included, but what, because there were multiple home
Right.
invasion counts, they just took one of them?
Yes.
As, and the other three he was sentenced on the other three?
Right, so that really brings up a real anomaly here, because if it did merge, let's say it was just the one home invasion and it was 30 to 35, and it did merge, then Laporte would actually benefit because his longer parole eligibility would go away, and he would have the shorter parole eligibility based on felony murder.
Did you go back to the trial judge on the sentencing issue?
No, we did not, because we viewed it as a constitutional question appropriate for this court to review.
So is it your position that in all cases going forward, every juvenile convicted of any crime must be parole eligible after 15 years? Or is it your view that because at this time, 15 years was the parole eligibility, that since there's no crime more serious than murder, that the 15 years is only appropriate here, and we'd have to revisit whether or not for crimes committed after 2014, it should be a higher minimum?
Yeah, I mean, I would say, I mean, at this time, it was 15, and that's what should be applied to Laporte. I mean, I guess the 20 years, if it was a similar situation after the new legislation, that would be a separate question. But I would say that at least 15 here, it should at least be consistent with his parole eligibility for, I mean, that goes to the proportionality. It should at least be consistent with the parole eligibility for a much more serious crime of murder. So that it's proportionate at least. I mean, it probably should be less than the 15 years, but at least it should not be more than the 15 years.
Let me ask a question because I'm confused about this. The home invasion, there were how many counts of that? There was only one home invasion. I get it that there were other robbery victims, more than one robbery victim, but there was only one home invasion.
Yeah, there was 4 counts of home invasion. I guess it was to each individual who was present in the home. It's not something that was challenged. Maybe it should have been, but it was it was not, the jury came back with the 4 counts of home invasion.
But it's, in this case, even if it was 1 count, the trouble with the merger, I think, is that the murder happened quite independently of the home invasion. I mean, it was as they were leaving. I mean, in other words, the merger seems to me is when the act that is the invasion is also the one that killed. I mean, this just seems to me there's a temporal separation here that would make it
Well, I
not
guess
mergeable
that
anyway.
that would make it not a felony murder if that is
Well,
true.
no, I still think it's just.
But you're not arguing, I don't hear you arguing merger. I hear you arguing that if there were 1 home invasion and he was found guilty of felony murder with home invasion as the predicate, we would dismiss the home invasion as a lesser included of felony murder.
Right.
You're not arguing right now that the use of the home invasion as the predicate was inappropriate because it was merged.
No, that we're not arguing that right now.
Sorry, I misunderstood.
Can you help me with Cologne? No, I'm sorry, not Cologne. With regard to Daniel, do we have anything said by Daniel during the course of the crime that indicated that he believed that it was your client?
No, I don't believe it was, and according to the judge's order and the motion to suppress, Daniel wasn't permitted to identify my client at the trial, and the order is in the appendix.
Well, your client was allegedly in the other room.
Right.
And he only had a brief moment to see him.
Right.
Going through. So there's nothing to do with a broader issue of the independent source rule. It's just that in these facts, you couldn't say by clear and convincing evidence that there was an
Right,
independent source.
exactly. That's, the trial judge didn't allow him to identify my client. He only identified Wiggins.
Right.
And with regard to Susan, she did identify your client.
Right.
And I'm a little bit confused. At the show-up, did she say there was, the judge's findings, I think at one point say that she said he was most likely the intruder, and then he referred to it as a positive ID, and then in the briefs it's referred to more than likely. What precise words did she use at the show-up to identify your client?
I really don't recall her precise words. I think she asked to hear him talk, and then she said, that's the same voice.
Did she say anything at the scene? There's some reference in the briefs that she told an officer at the scene that she recognized Laporte. You recall that there was testimony at trial that she told somebody
Yes,
at the scene?
I believe you're correct.
And do you recall what she said? Was it the voice she recognized? Was it
I think it
him?
was she said voice and the way he walked. I'd like to return to the constitutional argument of the sentence. It's also not only disproportionate to the murder offense, but it's disproportionate to Mr. Laporte as a juvenile. I mean, there's this national trend for less severe sentencing of juveniles that started with Roper, Graham, Miller, and now Montgomery from the U.S. Supreme Court, and this court's Dicheco and Brown. And the scientific research that's cited in Dicheco that says that juveniles are brain is not fully developed by 18, and at the
You saying therefore that the 2014 statute, as it relates to extreme atrocity or cruelty, is unconstitutional on its face?
I'm not arguing that, but that, is a possible interpretation for the court. I'm really arguing that in this case, based on the felony murder, that the 15 should be I guess what I'm saying is considering everything together. He's a juvenile. It's recognized that at the time of sentencing, a judge can't know that this individual is deserving of the most severe punishment. That's what this court said in Danchenko, that it's a combination of him being a juvenile, the sentence not being as, is not being as severe as murder.
I don't want to put words in your mouth, but
Okay.
at the time of the sentencing,
Yes.
tell me if I'm wrong.
Okay.
Danchenko's not out, and it's a first-degree murder.
Right.
Now what you have is another indictment has a minimum sentence that's way above what is now the parole eligibility for murder of somebody under 18.
Right.
And is it that disparity that raises the constitutional issue, or are you just saying beyond this case, the pure number is unconstitutional?
I'm saying the disparity is one part of it, but it also relates to, I'm not saying that that's that number. Like, the Commonwealth argues that it doesn't deny him a meaningful opportunity for release. And that's just one part of it.
No, I understand.
But that's the underpinning of Diachenko, isn't it? I mean, the reason why Diachenko was decided the way that it was decided was because the juvenile defendant had no opportunity for parole, but that's not the case here.
Well, I mean, one of the aspects of Danchenko is that it has to be a meaningful opportunity for parole. For example, cases from other states say a geriatric release is inadequate. And I cite the Iowa State versus Pearson, where they found that 35 years was not enough to give a juvenile a meaningful opportunity.
You mean it was too much?
It was too much. And same thing with the Wyoming court in Bear Cloud, 35 years. And Cassiano cited by the Commonwealth, they found that 50 years was not, there was no meaningful life beyond prison. And they also left open whether a lesser sentence might also be inadequate.
So this would be 47 years minus earned good time at a minimum, starting at 15 years.
No, they're concurrent now, right?
They're concurrent, yes.
So it's not 47.
But as my understanding, that, as Judge Gant said, that good time wouldn't start until the murder parole eligibility started. But regardless, I mean,
No, I think it's,
No, the home
it does
invasion.
not start until the mandatory, it's a mandatory minimum of 20 for home invasion, I
Okay.
believe. And I don't think you get any good time for the period of a minimum
right.
mandatory. The good time kicks in only for a sentence above and beyond the minimum mandatory.
I
That's
see.
what I'm saying.
Was there a sentence on the armed robbery?
Yes, the sentence on the armed robbery was 20 to 30 years.
Do you mind going on to, I don't really understand your argument about the DNA.
Yes.
Could you explain that to
Yes.
me?
There was analysis of a sweatshirt found in Laporte's closet, and gunshot residue was found on the sweatshirt. DNA testing included the decedent and excluded Wiggins, and there was inconclusive results for Laporte, for my client. Following a motion, the trial judge excluded testimony relating to this inconclusive finding. However, the Commonwealth prepared these large charts, which I saw in the courthouse, that, to be placed on an easel. 3 large charts. One of them was just the DNA findings and all the numbers for the defendants and the decedent. One was analysis of another sweatshirt, and then one was analysis of this sweatshirt. And the chart included not only, it included Laporte's DNA profile and this inconclusive profile that was excluded in testimony, but it was still there on the chart. And what it was there was 15, peers for DNA, and out of that, 9 of the locations had numbers relating to that were matching 2 matches with Mr. Laporte, and the other 6 were matches, one number with Mr. Laporte and an asterisk. And the judge's solution to this was to block out Mr. Laporte's profile on this particular chart while still submitting these 2 other charts that had his profile. It's reproduced in my appendix, and it's a reduction, so it's not as clear as it was in these large charts, but you could see the numbers on it. It was just blocked out, so of course the jury's going to say, like, you know, obviously it's Laporte's profile that's blocked out, and they have it on 2 other charts, so they could easily compare it. So it allowed the Commonwealth to introduce this inconclusive DNA testing that this court has found it irrelevant and shouldn't be introduced in Nesbitt and Matai in cases cited in my brief, and was highly prejudicial because
Aren't you saying that it wasn't admitted? Aren't you saying that the redaction and the limiting instruction wouldn't have been effective in that situation?
yeah, I mean, the redaction,
Is that your point? It wasn't, the inconclusive DNA evidence as it were related to Laporte and that sweatshirt were not admitted in evidence.
well, it was admitted to the extent that the inconclusive DNA results were on this chart that was redacted.
And I completely appreciate that.
Okay, and then 2 other charts were sent in that had Laporte's profile on it.
I
So
appreciate that. So but the inconclusive DNA was not admitted.
it was not
as it
admitted in
related to that.
it was not admitted in testimony.
Okay, it's not admitted. So then what you're saying is that admitting the other 2 charts and the redaction here, despite the limiting instruction, did not cure what the jury might have inferred.
Right, right. I
Not
mean,
that something was inadmissible and admitted, because it wasn't admitted.
well, it was admitted to the extent that it was on the chart. I mean, there was no testimony about it. but-
It wasn't part of the evidence. It was blocked out with a limiting instruction and a curative instruction, right?
Well, it was just a general instruction not to speculate. It wasn't like,
So the question is whether or not that was enough of a curative instruction.
right, and I say that it barely is. It was just a
Okay.
standard speculation.
Well, I appreciate that.
And it's just as if there was testimony brought in instead of live testimony. They were given these charts, which, you know, even though it was redacted, it didn't stop them from looking at the other 2 charts that had exactly the same information. In fact, it probably made them more curious as to what was redacted. Because as you can see in my appendix, it's just like they put in the chart with like this long strip covering up something.
Were the charts for different items of clothing?
One chart was just the DNA results for the decedents and the defendants.
No.
Okay.
One was for another sweatshirt, or 2 other sweatshirts, and one was for this sweatshirt, which is 5'8", which,
Okay, so why, I guess I'm not getting it, insofar as if your client isn't mentioned, why wouldn't the jury think that his DNA isn't on that sweatshirt?
well, because a comparison of the numbers would implicate my client. As I said, out of the 15 pairs in the numbers, 9 of them were a match, and 6 of them were the one number and an asterisk. And so they could have easily looked at these other charts and said, oh yeah, that shows Laporte. And if we had more information, that would have shown that he was on this sweatshirt.
Okay, thank you.
Thank you.
Ms. McMahon, good morning.
May it please the Court, Catherine McMahon, Assistant District Attorney for the Hampden District for the Commonwealth. In this case, Angel Colon overheard the defendants, who were friends of his, friends of Daniel Bennett, an acquaintance of Susan Bennett's, because they were often at the Bennett home. They knew that Daniel had purchased a new Xbox system, and they wanted to take it. On the night of the armed home invasion and armed robberies, Cologne called 911 before Tracy Bennett was shot. She was shot during the 911 call. And he did not identify the assailants in the 911 call, but at the scene, he told Officer Kalish that he recognized both defendant Wiggins' voice in Daniel's bedroom and defendant Laporte's voice in Susan's bedroom. He was with Susan. They were attacked in Susan's bedroom. Daniel told Lieutenant Clapperud that he didn't have any black customers. He sold marijuana, but he did have 2 black friends named Max and Swinkles. Sergeant Duda spoke to him at the scene, and he said that he thought he had heard Max's voice as the assailant of him in his bedroom. Susan told an unnamed police officer at the scene after she washed her hands after tending to her mother that she thought she identified Swinkles, at least by his voice. I'm not sure whether she also said that she identified his walk. And Daniel also called Wiggins' sister, his former girlfriend, asked if the defendant was with her, and said he hoped that he wasn't involved in it, and tried to take his mother's car keys and her car to go after the defendant, Wiggins, to make sure he wasn't the assailant. So at the scene, Cologne identified both defendants by voice. Susan identified one defendant by voice, and Daniel identified one defendant by voice.
Okay, let's go back to Susan. What precisely did she say at the scene?
At the scene, I believe she said that she identified Swinkle's voice. They used their first names. They didn't use their last names. Cologne gave their first names and also gave the streets that they lived on, although he was mistaken about one person. He thought it was Price or Prince Street, and I think it was Princeton Street.
Now, I know there's a difference, I think there's a difference in the briefing, in that the defendant claims that Susan merely said that the man's voice and appearance seemed familiar.
Now, at the scene, she testified at the motion hearing that she told a police officer that she recognized Swinkle's voice. She said his name.
I'm sorry, is that what, I mean, the motion hearing, she said that. What did, if you were to speak to the officers as to what she said then?
The officer wasn't identified, and no officer confirmed what she said.
So we have no officer testimony
About
what Susan said?
What about Susan said at the
Relying
scene, it
upon what
came
she
from
said-
Susan.
You rely upon what she said at the motion hearing, which was after the suggestive ID, as to what she said at the event?
Well, they all testified at the motion hearing as to what they had said at the scene. What Daniel said and what Cologne said was corroborated by police officers, but there was no identified police officer who Susan spoke to.
Was this, is this the same, who was it that she wanted to hear the voice of and then said it's his voice?
Swinkles, or defendant Laporte.
So it's the same?
Yes.
And so when she, at the motion, so that had happened, so when she's testifying at the motion hearing that she said this, she's already had that voice ID, obviously?
Yes, at the motion hearing, they had all had the voice ID. Shortly after,
How can you say she was so sure? I mean, you've got no officer saying, no officer says that Susan identified Swinkles or Laporte as the voice she heard. And then when she gets and does a show-up where she's looking at him, she says, have him speak to me so I can hear?
they all recognized the defendants.
Well, of course.
Because they knew him.
Because
So
their masks
the
were off.
corporeal ID was like, they knew that's defendant Laporte and that's the defendant Bennett. They knew them. So she and Cologne said that their physical appearance was like that of the assailants. She asked Detective Devine if she could have defendant Laporte speak. He had him speak the words that she had heard during the altercation, and she said it was most likely the assailant.
So even after we have this suggestive voice identification, she doesn't say it's him. She says it's most likely him.
She said it's most likely him. When
And then-
Cologne heard their
and-
voices,
and
he
then-
was
and then
positive.
Cologne, I understand. Cologne's a different story.
Daniel said he didn't think it was Bennett and he wasn't sure about Laporte.
And then when she did the in-court ID, did she say it's most likely him, or did she say it's him?
in cross-examination by counsel for defendant Laporte, she repeatedly was asked whether you said it was most likely, and she repeatedly agreed that that's what she had said during the show-up ID.
Right, I know that, but
When
what
she
did
was testifying at trial about her recollection of events, she said she identified him by his walk, by his build, by his voice, by his skin tone.
But did she say she was positive at trial?
I don't know if she used the word positive, but she was, the essence of her testimony was like, that was the person who had attacked her and Cologne in her bedroom.
Okay, so she was, whatever the words were, she was unequivocal at trial.
Yes,
And she said most likely earlier on.
yes. And
So how is a defense attorney supposed to cross-examine somebody as to the unequivocal nature of the in-court ID without getting into the equivocal
well,
but
they got
suppressed?
into not only what words were used at the show-up ID, but they got into how the show-up ID was conducted. And they called an expert identification witness, a psychologist, who testified about how your confidence can be increased by feedback, how there's no real relation between confidence and accuracy, how voice identification is very poor, what a good voice identification is, which the jury could compare with how the voice identification was conducted here. It was conducted completely differently from what she said it should be, and how she explained it should be was consistent with the Marina case, which was the reason why the motion judge suppressed the show-up ID here. Because it was corporeal at the same time as the audio. It was a show-up as versus a lineup, and they said exactly the words that the witnesses said the perpetrators had said to them during the incident.
So what was
We had-
so what was the clear and convincing evidence that was independent?
What they said at the scene, and also their great familiarity with the defendants.
But at the scene, the judge had no information at the scene of any officer saying, this is what she told me, with regard to Susan.
He had her, and he credited her.
But I mean, she credited her testimony as to what she said at the scene in terms of her certainty after the suggestive identification and after they're charged. I mean, isn't that exactly the problem?
Well, the fact that we don't have corroboration for what she said at the scene, but we can accept what Daniel and what Cologne said at the scene because there's police corroboration.
Well, helps.
It does help, and we don't have it for her, but the motion judge credited it, and you can't throw it out. It's there, and she lived in the same home as Daniel. The defendants visited him like several days a week. Daniel and defendant Bennett had been friends for about 4 years. It wasn't simply a very quick thing. The motion judge found that her bedroom was well lit with a light in the ceiling and with the television on. She and Cologne observed the two men walking down the hall. She's familiar with the defendants. She recognized Laporte by the way he walked. She described his walk as distinctive, like a sway. They were detailed in what they said that the assailants wore during the incident. At the show-up, they were dressed completely differently. They were not in the hooded sweatshirts and the baseball caps and the long pants. They were in T-shirts and jeans. So, and they were very consistent in their descriptions of what the assailants had worn. They were consistent in what the assailants had done to them in the room, what they had said, how many times they said it, who was struck, whose hair was pulled. But so there was a good opportunity. It wasn't a fleeting opportunity for them to observe the assailants at the time of the incident, and there were people that they recognized because they knew them.
Aren't you really saying that whatever led to the judge's finding that the out-of-court ID was unnecessarily suggestive, whatever happened at the scene, whatever words we used, does not dictate the limitations of the evidence before the judge, on whether or not there's clear and convincing evidence of an independent source.
It's supposed to be independent.
Right.
And if you couldn't look at what happened before the show-up ID, it could never be independent if you always if we don't do reliability, we do independent. And so the show-up, the unduly suggestive show-up happened. You have to find it's independent. And it can't be, if we're going to have an independent source test, it can't be that the fact that there was an unduly suggestive thing means they can never be independent.
That's precisely my point, although I don't think I'd go as far as you. I mean, I think what happens at the out-of-court ID can factor into the judge's calculus as to an independent source and what was said as it relates to credibility and many other issues. But the point is that the analysis of the independent source is not limited by what happened at the unnecessarily suggestive out-of-court ID.
No, it's what happened during the crime.
Right, but I mean, but if you're right, she knew them. If you're right, that she would have told the cops, I know who did it. It was Swinkles and it was Max.
She said she thought it was Swinkles.
Well, she said it was most likely. Even after she heard the voice, she said it's most likely. But at the scene, she didn't tell the cops, it's these people who I knew so well.
No.
So how can
She said that she recognized one.
at the motion
Apple.
hearing she said that, but there's no.
There's no independent corroboration for her testimony, which the motion judge credited, that she had told the police officer at the scene that she recognized Swinkle's voice.
Okay,
And then
but I mean,
in
but
terms
if it's to be independent in a situation where somebody knows somebody, if it's truly to be independent, why should there not be compelling evidence that the person before the suggestive ID said, I know who it is, it's Max and Swinkles? I mean, I understand if that's the case, then of course the fact that it's suggestive wouldn't matter because she already said that, and you can't say it was affected by it. But you don't have that as to either Daniel or as to Susan.
And,
here.
well, Susan, it was an unduly suggestive procedure. The motion judge found that. The Commonwealth is left with that. But Susan identified Laporte most likely at the show-up ID. Daniel didn't identify anyone at the show-up ID. He said he thought it was Max at the scene. After he found out that his mother had died, he ultimately said it was Max at the police station. But even at trial, he said he wasn't sure that it was Max. I think one of the last questions that the prosecutor put to him on redirect was, you still don't know that it was Max in your room that night? No. And his inability to be unequivocal about Defendant Bennett could reasonably be inferred to be because they were close friends. He felt he couldn't believe that his friend had done this to him and to his family.
There's absolutely no other reason to ask the question on redirect, other than to have the jury try and draw that inference.
Yes.
Otherwise, you'd never ask that question on redirect.
So,
Okay, well, let's go back to Daniel. Do you agree with your brother that he identified Max as the person after he was told that we found this at Swinkle's house?
no. The testimony was that he saw his property. He was not told where it came from.
But it was after he was told that his mother died?
Yes, it was after he was told that his mother died. He broke down hysterically. He was told to think real hard, and that's when he said it was his friend Max. At trial, he went back and forth as to whether I knew it was him when he came through the door and pointed the gun at me, to, at the end of his testimony, saying he wasn't sure that it had been him in the thing. So this isn't somebody whose confidence was bolstered by the show-up ID. This is somebody who equivocated back and forth throughout. But you also have Angel never equivocated, and whether his confidence was bolstered from the show-up ID or not, you had expert testimony to the jury explaining how confidence doesn't relate to accuracy, how weapons focus, cross-racial, all the factors that in Gomes are now put in the standard instruction. The expert testified to all of that. So the jury had not simply the defendants having to rely on their ability to cross-examine witnesses who are now more confident than they were at the time. They also had expert testimony for the jury to consider when they're considering the demeanor and the confidence of the witnesses on the stand. And you have also not only the defendants' alleged planning to take Daniel's property, but within 50 minutes of the robbery and the killing, in a closet with sweatshirts with the defendant's wearer DNA on them, is some of Daniel's stolen property, 50 minutes away. So you have that as another linked in.
Now, I want to turn you to page 51 of your brief, note 28. Help me to understand what you meant. Last sentence, where the identification evidence was a major focus of the trial.
I'm not arguing that
Commonwealth
it's
cannot
harmless.
say that so you're not arguing that it's harmless?
I can't. I struggled with this, but the eyewitness identification was a central focus of the trial. There were, Cologne and Daniel were on the stand for I think Cologne was on the stand for part of 3 days.
Okay, but
So,
let me separate out a little bit. What if Cologne's testimony is okay? Do you still say it's not harmless?
No, if his testimony is okay, then we've got a positive identification by somebody who was there of both defendants, and I think with it carries the day.
So you're saying if we knock out all of the
If we not,
Court IDs.
yes, if we knock out all of it, because it was, the jury heard it, the jury relied on it, there's even an expert talking about eyewitness identification. Despite the fact that there's other compelling evidence, I can't say that the identification evidence didn't have an impact on the jury. I can't. Because of its centrality to the case. I don't think you can just take it away because you're supposed to look at everything together, and it was there, and it was a big component of it was a very lengthy trial, but the identification was key to this very lengthy trial.
Was there evidence as to whether when the two perpetrators came into the house, they were wearing the same things that the two defendants were wearing when they visited there 2 hours earlier?
No, and only one of the defendants had visited 2 hours earlier. There was testimony that he was wearing his sister's sneakers when he visited.
Bennett? Was it Bennett?
That was Bennett. But he was not dressed in
He didn't have on
the hoodie and the baseball cap.
Bennett.
Okay.
Bennett.
Okay.
I'm sorry, Bennett.
Wiggins.
Bennett, you mean Wiggins, or you mean?
Wiggins, I'm sorry. I'm so sorry. So, and then when they're apprehended outside of Laporte's home, with about 45 to 50 minutes later, they're wearing T-shirts and shorts. They're not wearing the long pants and the hooded sweatshirts. Cologne identified two of the sweatshirts that were removed from the closet in Laporte's home as that one is defendant Wiggins and that one is defendant Laporte's, and the wearer DNA confirmed. He positively identified the sweatshirts belonging to the people that the DNA showed had worn them. There was the third sweatshirt found in the closet, and if you want me to segue into the DNA evidence or stay on this.
Well, before you go there, he could do that because they were different in color, or because they were different, the
They
two
were-
sweatshirts?
One was like a XXX size. The other two, I think, were the same size, but one of them had a zip up front, and the other two were pullovers. They were all black Champion hooded sweatshirts. The larger one had the wearer profile of defendant Wiggins. One of the smaller ones, I think the zip up one, had the wearer profile of defendant Laporte. The third one had gunshot residue on it and also had a DNA profile from which Tracy Bennett, the victim, could not be excluded. The numbers are like 1 in 6 of the Caucasian population. It's not a very powerful length, but she couldn't be excluded from it. As to the wearer DNA on that, she was excluded. Defendant Wiggins was excluded. It was inconclusive as to whether defendant Laporte was in or out. The DNA expert did not link Laporte to the sweatshirt at all. The trial judge ultimately redacted his profile from the chart that wasn't timely objected to. It wasn't objected to until after the witness had testified using it. The fact of it being inconclusive as to him was never made to the jury. The jury was told not to speculate, and the trial prosecutor did not try to link either of these defendants to that sweatshirt, which is found in a closet with many items that had defendant Laporte's DNA on him.
But the bottom line is the inconclusive DNA line that was redacted, that was never admitted in evidence.
It was not
So
admitted
to
in-
the extent that there is some sort of an issue here, it would have to be a 33E issue that curative instruction and the redaction, despite that, there was a substantial likelihood of miscarriage of justice.
Yes, and counsel for defendant Laporte asked, actually defendant Wiggins asked questions of the chemist about the showing of just asterisks, and she testified that it had to show with the complexity of the mixture, that the mixture was at least 4 people, at least 4, but she couldn't give a top number. It could be 20, it could be more than 20, but it was a complex mixture, and she did not draw any conclusions about it matching anyone. Now, there was evidence allowing an inference that there was a third perpetrator. The fact of the third black sweatshirt with the other 2 with some of the stolen property. The fact that somebody just before hearing the shooting saw a truck traveling very slowly in the direction from where the person later heard shots, and that there 2 men are seen running wearing all black, one of them clutching a bag, but there were at least 2 bags of property taken from the victim's home. Daniel packaged stuff up in his room in a plastic bag, and the assailant in the other bedroom packaged up the stuff from Susan's bag. Only one is seen carrying something as these 2 men are running away, and another person sees one person running away separately. Not all of the property was recovered. I don't know that any of Susan's property was recovered. Not all of Daniel's property recovered, although a great deal of it was from the closet in Laporte's home. The murder weapon was not recovered. The prosecutor argued that the sweatshirt could have been worn by the third culprit. She never linked it to either of these 2 defendants, so she never used the inconclusive DNA to link it to either of these 2 defendants. It just went to her theory of there being 3 perpetrators.
Can we turn to Mr. Laporte's sentence for a moment?
I know that,
Sort of a strange world in which you found be guilty of felony murder, home invasion,
and armed robbery.
and armed robbery, but you're going to get a longer, you can't, it's the home invasion which keeps you in prison.
Well, home invasion and armed robbery are both possible they're life felonies.
Right, but they
Right.
have different different minimums.
They have different mandatory minimums. They're both inherently dangerous. And in this case, there were 4 victims of armed home invasion, and the appeals court in Commonwealth versus Anton Marchi used the victim as the unit of prosecution. This court has also said you can charge 1 armed home invasion for the number of people who are there, or you can charge according to the number of actual victims. All 4 people in there had guns pointed to them. The 2 men were physically assaulted. Susan's hair was pulled. At gunpoint, their property was demanded of them. They were victims independent of the felony murder. So the defendant should be punished for what they did to the other people as well. In other jurisdictions for non-homicides, courts have discussed whether something was the equivalent of a life sentence without parole. That's not what this is here. The bottom parole eligibility sentence jibes with the 214 amendments. I understand that for non-homicide life felonies, I think the minimum is now 15 in that statute. But here, the defendants he was 17 when he committed the crime. He was about 20 when he was tried 3 years later. So being parole eligible 30 years minus what he got for jail credit for being held beforehand and whatever good time credits he has after 20 years is not the equivalent of a life sentence.
What about the disparity between the 15-year parole eligibility and the 30-year minimum?
The fact that murder is something for an adult is life without parole. These other crimes are very serious, inherently dangerous crimes that are life penalties. I think they're very serious too, and they're deserving of a serious punishment. Here where there's several victims.
Should there be a remand?
One of the defendants had moved under Rule 30A for resentencing, but then withdrew the motion after a prior ADA had responded to it. But
with respect to the home
trial
invasion,
judge is now retired, so would have to go to a different judge, and you know the record. It's huge in terms of trying to refashion a sentence.
with respect, I just don't remember this if I ever knew it, but with respect to the 4 home invasions, were they, are there 4 concurrent sentences, or was something else done?
There are 4 concurrent sentences, and there's 2 concurrent sentences for armed robbery. And the Commonwealth's position is that the jury came back guilty on all of those indictments. Each of those crimes was considered by them for felony murder. They came back guilty on felony murder. One of those offenses merges as duplicative, but the rest stand. And because the Commonwealth's entitled to the greater sentence, armed home invasion with the higher mandatory minimum is the greater sentence. So the Commonwealth proposes that one of the armed robberies be dismissed as duplicative, the other armed robberies stand, and all 4 armed home invasions stand. They're all concurrent with the murder count.
So I guess the question is not whether home invasion is a serious crime. Of course it is. But the most serious crime we have is murder. And so why is it that the person is eligible for parole on the murder before he's eligible on the home invasion which resulted in the murder?
The reason why we have life with the possibility of parole now for murder is because not to have a possibility of parole is extremely atrocious or cruel under the state and federal constitutions. The other sentences are not life sentences. They don't exactly fit into Miller and Diachenko. So the question is whether those are tantamount to or the equivalent of a life sentence before the person is parole eligible. If you're going to pull the Miller-Diachenko rationale over into this for non-homicide offenses, and because they're not equivalent to life without parole, they're not implicated by Miller or Diachenko. And I know that this court, in one case out of Hampden County, which is going to be heard in April but isn't fully briefed, is Commonwealth versus Fernando Perez. And I think it was docketed at the end of 2016. In that, juvenile received consecutive sentences of, say, 5 to 7, 5 to 7, 5 to 7. I'm not saying that that's exactly the number, where there were different victims of an armed robbery spree. And the defendant is now challenging under Miller and Diachenko those consecutive sentences where the person's not going to be parole eligible until having served, I think, approximately 30 years. So this issue is and it may be here before you in other cases as well, but I know that there's one case out of this county, which will be scheduled for April, that has this issue, and because that's the only issue, it's fully briefed rather than trying to shove it into a kitchen sink kind of a brief with multiple issues with a huge record. And I apologize for the summary nature of the argument, but in reviewing other jurisdictions, if it's not tantamount to or equivalent to life without parole, it doesn't fall within Miller and Diachenko's concerns. Unless you have any other questions about the other issues?
Could you talk a little bit about the issue of the severance and the co-defendant not objecting to the identification discussion at the police station?
Counsel, let me clarify one issue that Justice Botsford, I think you had a question of. It was when counsel for defendant Wiggins was questioning about the show-up procedure concerning defendant Laporte. Counsel for defendant Laporte said, on the record, I didn't object. I had a strategic reason not to object. And if he hadn't asked the questions, I would have asked the questions. So it was clear that the tactic was to attack the show-up ID, to question what was said before and what was said at trial.
That was for Susan. That was with regard to Susan's out-of-court ID.
Yes. When counsel for defendant Laporte was questioning about Daniel at the police station, he elicited without objection from counsel for defendant Wiggins that Daniel, after learning that his mother had died, had ultimately said it was Max who had been the person who attacked him in his bedroom. No objection then. 3 days later, when the prosecutor is going into that same territory, there's an objection and there's a motion to sever the case and a motion for a mistrial.
But wasn't the objection sustained?
The objection initially was sustained with the judge saying it was deemed suggestive the Commonwealth can't get into the show-up ID.
Error, if it's a substantial likelihood, you have to go back 3 days earlier, and the failure to object to the co-defendant's examination.
Yes, because he moved to mistry and to strike what was said 3 days before. He didn't do it 3 days before. He did it then, and only after the prosecutor tried to go into the same territory. The judge ultimately said that he has to weigh probity versus prejudice, that he thought the defense had opened the door slightly, that it was the motions to sever and for mistrial were not timely, and he was going to allow the prosecutor to ask just one thing, and she elicited exactly what counsel had elicited 3 days before, that it was after he learned that his mother had died that he said it was Max, period, nothing more. So it's cumulative of what happened on the prior cross-examination of the other witness. So with the tardiness, with the fact that they're only objecting to it 3 days later, once the prosecutor tries to broach the same issue, there's no substantial likelihood of a miscarriage of justice. And again, Daniel was the witness who still on the stand, it was like 3 days before, but he couldn't say for sure that it was defendant Wiggins who had been his assailant. He went back and forth, and I think the last thing that was elicited of him from the prosecutor was that he wasn't sure.
Okay, thank you.